Yeah, I'd like to call the Tennessee Board for Licensing Contractors meeting to order. We'll start with a roll call vote. To my left.
Ernest Owen, here.
Bill Mason from Greenbrier.
Keith Whittington, Johnson City.
Jerry Hayes, Paris.
Mark Brudd, Knoxville.
Reese Smith, Franklin.
Cindy DeBusk, Knoxville.
First item on the agenda is to review and adopt our agenda. Are there any modifications to the agenda?
Make a motion, we approve the agenda.
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. First item is hardships. Should be in your iPad.
Move to approve.
Second.
Second.
Any discussion on the hardships? All in favor of approval, say aye.
Aye.
Opposed? Motion carries. All right, next item would be to review and approve the March 2013 board meeting transcript.
Mr. Chairman, I sent two relatively small changes to the staff by email. I can't remember what they are at this point, but they were material changes. I think one of them misdesignated the executive director or something of that nature, and the other one was a grammatical mistake. So I would just suggest when we approve or ask that those two changes be included.
Okay. Any other corrections? We have a motion for approval.
Move to approve with those two changes.
Second.
Okay, all in favor say aye.
Aye.
Opposed? Motion carries. The interviewed contractor applications is the next item for approval. Go ahead, Cindy.
Okay. I have one that's on the list, 66883. The gentleman, he has a felony, and after interviewing him, I'd like to for 66883.
My list of scheduled interviews candidates does not have license numbers on it, but
Okay. You want the name of the company?
can we say the name of the company?
Yeah.
Okay.
It's 615 Electric LLC.
Okay. Any others?
Have one for Metropolitan Contractors. At the last meeting, he may have been approved by, I don't know who it was by, but he said he had been approved, and he has his documentation that he was showing me. And I was given his application again today, which had numerous violations, but only one conviction. So I wanted to bring him to the board to let them make a decision. I didn't see who approved him the last time. I don't know whether it was Marvin. He's probably the only one that's not here. It may have been Marvin. So would you all like to talk with him? Because he says he hadn't been in any trouble lately, but that he wasn't charged with any felonies or anything lately, but he has a list of violations. No, he has been here before.
Well,
But it
is
is
a
a
new
new
license. He was here last time, though, and I think the individual board member, it may be Ronnie, I remember it's one of them. And then when we got to the full board discussion, Bill may remember there was some confusion and somebody stole a lawnmower, was one of the guys, and then
we had a mix-up of two different felons that they had interviewed, and one of them we got straightened out, and the other one I can't remember though now if we decided to postpone it till today. Obviously, we have postponed it till today.
Well,
so.
I think the most pertinent question is how many felonies does he have on file? First off, I'm not sure what the
He's saying he has only one felony. But I see different charges, and on these sheets, it doesn't tell me whether it was a felony or not.
What we really need, I think, is a TBI background check, and I think we asked him to provide that, but the only thing he provided was a Shelby County background check. So I think the TBI. You brought the TBI? Okay. Do you have it with you? Oh, okay.
Well, while Ernest looks at that, can we let me go ahead and do my 3 interviews. I talked Lake Point Homes wanted a name change from Timberline to Lake Point, and there was a question about them using Lake Point, which is an existing company name in their advertising, but they did all their contracting under Timberline. I didn't really see a violation, so I recommend that we go ahead and approve the name change. Leon Williams Contractors, they were brought in for a possible violation, but Jenny and Talise and I sat in and talked to him. It turned out there was no violation, so I moved that his application for a increase in limit from $1,440,000 to unlimited be approved. And Manning Windows of Sevierville solicited prior to application, and I recommended a $250 civil penalty, and he has to update his certificate of insurance before approval. So that would be my 3 recommendations from interviews.
I have another one from Magnum Enterprises. He had a drug conviction. He did his time. Well, he was put on probation. He worked for the post office, and he went through a program at the post office. And he had been there he retired at 30 years without any other problems. So I'm recommending him for approval.
Okay. What about Metropolitan?
I'm looking at the background check right now.
I've got 2 while she's doing that. The first one is Lake Shore Road Pools. Guy was pretty elaborate. He's applying for a home improvement license after the fact. Had a complaint filed against him in which in Knox County, and I don't know how Knox County allowed it to happen, but he would get a owner's affidavit signed and then take that affidavit to the local building department there in Knox County and get a permit issued to him. I think finally on one of the 3 that we've found, and only 2 of them we can talk to the owners about, Knox County wised up to him and wrote they wouldn't do that anymore. And so he applied for a license, so I'm recommending a civil penalty on the 2 cases that we could confirm from owners that this had happened, $500 each for a total of $1,000, and issue the home improvement license. The next one is Tony Talaferro here in Nashville, roofing contractor. He claims He just changed jobs. He left the music industry and decided to get into the roofing business. And so he was ignorant to the fact that he had to have a license. He agreed to 3 jobs that he had placed on his application that were actually in Davidson County where a home improvement license is required. He agreed to a $250 each civil penalty for each job, and I'm recommending that we go ahead and approve his home improvement license and the $250 fine for each of the 3 jobs.
Okay. Anybody else got any?
I do.
Okay.
This is a reinstatement, but it's coming back to us as a new license. License number 54437. The fellow is convicted of a felony, and he is off probation and been cleared of all probation in the state of Mississippi, and I recommend him for approval.
What's the license name, Reese?
A Plus Plumbing Solutions. And I have one more that falls sort of into a no man's land. That's I want Jenny to help me on here a little bit.
Well, it currently is an open complaint with a consent order authorized by the board a couple of meetings ago. And so they applied for a license, and then at the same time we resolved the complaint during the interview.
And this goes back to something we've discussed for many, many years. Is when is the board notified that there's a complaint? Is it our next active board meeting, or is it when the contractor responds to legal? And as Bill says, that becomes a public record, and anybody can find out about it, including the board. And the reason I'm asking is but we don't have to hold this license because of the new law. Correct, Jenny? It's at our discretion.
Right. Carolyn was able to look it up, and that became effective upon the governor signing it.
Well, then I would move in this case that it's a $2,500 fine, and we issue the license today, or in the normal course with these applicants, as soon as we can.
What's the name of the firm?
It's license number, I know you don't have it, but license number 66871, and it is Blankenship Heating and Cooling, Lexington, Tennessee. So it's $2,500 consent order, and the license will be issued upon payment of that.
Chairman, I would suggest that I would move that we approve all the scheduled interviewed recommendations from the boards with the exception of the felony that we're about to discuss.
Also, Mr. Chairman, did you do one interview, I think?
I don't think they're...
Later on.
Okay.
So if you're ready, I could talk about
Wait, I just made a motion.
Yeah, let's vote on,
Okay.
or see if we have a second on Bill's motion.
Second.
That would be approval with certain civil penalties for all interviewed applicants except for Metropolitan. Any discussion? All in favor, say aye.
Aye.
Opposed? Motion carries.
I've taken a look at the background check, and to be honest, the TBI background checks can be unclear. I've dealt with them in other circumstances, but I can tell you some things from it. There is an extensive criminal history, but I can't, in some of the circumstances, I can't tell what the final disposition was, whether he pled guilty, except on a couple of them, and so I'll go down the list. So if you just let me read some of the violations. So it looks like the last problem that he had was in July of 2010 for speeding, and I don't think that was any kind of felony. And then at the month before that, in June of 2010, he got in trouble for driving on revoked. Again, I can't tell what the final disposition was, but just off the top of my head, I don't think that would be a felony charge to begin with. Then we've got the most serious charges, and a lot of them are driving violations. That's the most recent stuff. The most serious stuff I see goes back to December of 2008. He had a theft of property over $500. I do believe that may be a felony, but again, he could have pled guilty to something less, so it wouldn't be a conviction. I can tell that at one time it looks like he had a felony involving aggravated assault. That was back in '96. He also had another felony assault before that in 1990. He also had an aggravated robbery charge in 1990. He had some cocaine and marijuana possession incidences between 87 and 90. And again, I can't tell the final disposition of those, but for in 86 he did have a felony robbery with a deadly weapon. So I mean, I would say he's got some felony convictions, but it's hard for me to lay out exactly what the final plea was on the cases. Now, he may be able to speak to some of it. He's here today, but with what I have in front of me, I would say that he has some felony convictions.
So other than the driving, the most recent of I would consider the other issues was a theft over $500 when?
That was in 08.
Okay.
And then
What's your name?
Could you step up to that microphone? I can't hardly hear you.
I said that a lot of these cases on this charge, like, okay, let's talk about the deadly weapon, a robbery with a deadly weapon. I think me and a guy got to fighting when I was like 21 years old in 86, and it was dismissed. It never was a robbery. The theft of property over 500. One time I was in a house, my cousin's house. The police came in and raided the house. My case was dismissed. And the last one, the 2010, I was on a job. I was working for a company that grabbed the scrap plastic. I was working part-time. I was a driver. And at a Walmart that we stopped at, it was discretionary with the vendor, and we all ended up going to jail. And out of this decision of the case, I paid a $1,000 fine, and it was a misdemeanor.
what about the aggravated assault in 98?
Oh, that was my brother. A gentleman drove a car through my mom's house one time and hit his children. And when he came out the house, he really kind of was aggressive. Yes.
But you were arrested
And
with
I
him?
was arrested because I would not say it was his name. He said, the police said, well, I'm going to take you to jail if you don't say what it is. Okay, well, I got to go to jail.
Have you been convicted of a felony?
One.
And that was?
Marijuana possession with intent to
And how
sell.
old were you when you did that?
That was 20 years ago, so I might have been 29.
How much time did you serve for that?
8 months.
Okay. Have you spent time in jail other than that?
No, sir.
Ever?
Ever.
On any of these traffic violations?
I've never did any time, nor did the rest and bonding out. Never served any time on any of them.
Have you had violations in any other state besides Tennessee?
California.
What did you do in California?
I got stopped one time up there with a pistol, and it was signed.
Was it an unregistered firearm?
Well, back in them days, it was non-registered, but if you had it in the trunk unloaded, they pretty much dealt with it like
Okay,
that.
did you serve time for that? And what was the disposition of that? It was a
$9,000.
$1,000 fine. And no other violations in any other state?
Yes.
Well, the reason this board is concerned about, especially these property crimes, is that as a contractor or builder, what kind of license is he wanting?
Liability.
A what?
License, BCAR.
BCAR. Well, that's in people's homes.
I work at
And,
home every day. I'm
And that's why we're
electrician.
concerned about that, and that's why we're questioning you about it. And it seems like kind of a long list. But the last, it was 2008 theft over $500 that you were accused of. And tell me again the disposition of that.
We pled guilty to the theft under 500 misdemeanor and a $1,000 fine. I paid myself for a part-time job for Christmas. So I don't think that was really what I was intending on doing. That was after the criminal. See, one thing we got to understand: I've had a life during the criminal period, but after the criminal period, I've had a life too.
Shelby County license
Yes, I do.
for electrical.
Well, I work for Divine Electric. Yes, Roderick Williams. I got a bunch of references. I work for A to Z Construction. I work for Ashton A Construction. I work in the HARP program. I work in Shelby County Lead. I'm a lead contractor supervisor with the state also.
You got your driver's license
Oh,
back?
yeah.
Okay.
And about 3 more licenses.
Okay.
I've been going to school the last 3 years to get here. I didn't walk out of the prison. I've been working. And I go to school every year. I took the limited liability course. I took the Shelby State of Tennessee Lead. I took the Shelby County. I took the State of Tennessee Lead project designer. I'm a project designer. It's about 5 of us in this state, but I'm one of them. You know Miss White over at the Lead program. She knows me. I know the mayor, A.C. Warden. Guess what? That was my lawyer for most of those cases. Yeah, he knows me real well.
recommendation,
A.C.
counsel?
Warden, yes. That was my lawyer on most of those cases.
Well, I mean, if it looks like any kind of violent convictions or charges even were 10 years ago or more, and the theft over 500, I'm willing to bet wasn't a felony conviction in the end. I mean, I'm open to getting, I mean, I can suggest to him a place to get a better background check, or I can do what he wants me to do, which is call Shelby County. I can do it. I don't know exactly where I'll begin, but I'm sure I could get a better history on him. But, his most recent stuff was speeding violations, and he says he's got his license now, and the most serious stuff, like I said, goes back to 1990, 1986, and for the board to deny him on a felony conviction, I'd have to have more information. I mean, I guess you could, to me, it's up to you all, but if there's going to be a denial, I'd rather it be in July, because at this point I don't have solid proof of a felony conviction. We do have a grounds of improper conduct, but it sounds like that he's trying to do right, as far as I can tell.
Have you got a current driver's license? You got it with you? Would you hand it to Ms. To the counselor, please? Counselor, is it current? Okay.
Responsible behavior, as far as I can tell, and Ernest did the interview. He might be able to say how he feels. I mean,
Well, with only one felony conviction, and he says that's the only one that he has,
right.
I would move to approve it under those conditions.
Okay, we have a motion and a second. Is there any other discussion? Okay.
We approve this based on the next 2 years stays out of trouble, and
No violations.
we need to look at it for renewal.
Probation.
We asked that question at
The
renewal
renewal
time?
doesn't ask that question, does it?
Flag it.
Flag the file.
I mean, I don't know about a probationary license. I don't see anything in the statute for it, and we've never done one as far as I can remember, so I mean, you can try it, but if he wants to fight in 2 years and say he has a right to renewal no matter what this board said at this time, he might have an argument. I don't know.
Anyone have a right to renewal if there's been a felony in the meantime?
Sorry, say that again.
If he has a violation in the meantime, he's not got a right to renewal.
Yeah,
does he?
well, we'd have to do a formal hearing.
Okay.
To stop it. Right.
Let's just-
That's always the
Let's
case.
just flag it then, and
Yeah.
let's check it in 2 years.
I make it a condition of my license that I don't catch a felony.
Okay, thanks.
Okay. All right.
Well, now,
I will
yeah.
make that a condition.
Deal.
I forgot to tell you, I'm a Christian dude now, and I'm with God, and I don't do criminal. Ain't gonna get into that because that's such a long term. But I'll be willing to make that a condition. I'll be willing to bet on myself.
Okay, that's part of the motion then. He has no future felonies. All in favor, say aye.
Aye.
Opposed? Motion carries.
I've got something here that I hadn't had before. I have 2 increase requests that I have denied that I understand the whole board needs to vote on. Don't know how much of the details we need to get into. One of them had a negative working capital of $75,000. They do have a line of credit that brings them up into positive, and I don't approve that if a company has a negative working capital and the only working capital they have is borrowed money. That would be license number 27317, and I hesitate to give the name. But I would deny their request to have an increase from $1 million to $1.5 million at this time. And my reason is negative working capital. I move. It just got it they have $1 million license today, but I hear what you're saying. I'm not sure how they got it renewed in order to it said their expiration date is 5/31/15. That means does that mean they just renewed it this month? Well, my motion still stands, and I want to take a look at the file, and maybe it's in between meetings.
Okay.
Okay. And I have another one. We'll take them both at the same time. This is license number 43471. I actually had 2 other board members look in this. Their company working capital is $5. They do have a line of credit. And so I'm moving to deny their request to go from $350,000 to $1 million. That'd be license number 43471. I want to look at their file too. They're up for renewal 4/30/13, like right now. We probably have their application.
Any other revisions?
Into revisions now?
Yeah, I guess
We've
jumped
moved
in
from
now.
interviewed to revisions. Yes, we skipped waived contractors and home improvement applications. Let's go back to that. Are there any waived contractor or home improvement applicants that we need to discuss?
I want to bring attention to the board to one, just because I think the board would want to know this. And that's Babcock and Wilcox Nuclear Energy Incorporated. which has got an unlimited license, and I reviewed their file, and they're certainly more than well qualified to do it. They're going to be building a new small-scale nuclear reactor at Oak Ridge, which apparently is going to be a prototype energy in this country. And this is their license from us to be able to do that construction, but the Department of Energy and the Tennessee Valley Authority are anxious for this company to come in and do this. So I just thought the board would want to know that we're going to approve today a license for them to do that, and it's going to be, apparently it's a big deal in the whole development of nuclear energy in the country.
I need a motion to approve the waived contractor applicants.
I move that we approve them with the two denials mentioned by Mr. Smith.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. That takes care of the waived. The revisions, the two that Reese brought up, we have denied. Any other revisions? Okay. Let's have a motion to approve the revisions.
Make a motion, we approve all the revision applicants.
Second.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. All right, LLE applicants, any discussion on them?
Yes, Mr. Chairman. I make a motion that we approve the LLE applicants, the numbers that are listed. However, 46645, we will hold that one. We need work experience. And 48534, we will hold that one. I need a detailed explanation of the felony from Mr. Smith. So I make a motion we approve all the ones listed except for the two I just mentioned.
You have a second.
Second.
Any other discussion? All in favor, say aye.
Aye.
Opposed? Motion carries. The LLP applicants, any discussion on those?
There are none.
All right. We'll move on to pre-license exam course applicants. There are three of those proposed. I interviewed one of them this morning, whose license expired sometime in 2011. Since that time, we've received 2 complaints on them for offering their exam course without a license, one in 2012 and one in 2013. In addition to that, they are advertising on their website that they offer a no pay if no pass condition, which is a violation of our statutes. So Carolyn and I both talked to him this morning and proposed a $1,000 fine for each of the 2 complaints that we have, and proof that he gets rid of the advertising on his website that talks about no pay if no pass. And he has offered to pay $1,000 of the $2,000 to us and get rid of the no pay if no pass. I told him I'd bring that before the board to see what your opinions were, but my recommendation, I think Carolyn's is as well, is to
What about the advertising on the website? Is that?
He says that he can take care of that, and
Still a violation, isn't it?
It would be. Don't have a complaint on it, I guess, at this time, so. Is that part of the complaint?
No, it's not. I mean, what was presented before was based on unlicensed courses. Now, if there's some, that could have been there and I missed it. So, I mean, if I need to do a new consent order with those violations included, I can, based on whatever you all vote on.
That was the summary of the closed.
Oh, okay.
Closed and flagged because it was sent to the wrong address, but it was a no pay
Yeah, that,
$1,000 fine for that one.
yeah, I failed to mention that his reasoning for offering less is that their company moved in 2009 or 10, which was after they were originally licensed. So when we sent the renewal to him in 2011, he says he never received it because it was sent to the wrong address. And again, when we sent the first complaint to him, we sent it to the wrong address, so he said he never received that. We have since got his correct address and sent him the second complaint, and he agrees that he has received the second complaint. I've not made a motion. I have just...
Then I would make a motion, we take the recommendation of the executive director and
Fine, and removal of the no pay,
right.
pass no pay. Okay.
Second.
Any other discussion?
Mr. Chairman, this issue was brought to me when I walked into the door by Mrs. Gray, and it has reference to a BC licensing.
Are you talking about, let's just deal with this issue first, Ernest.
Okay.
This is not related to CBT development, is it? Okay. Let's vote on it. All in favor, say aye.
Aye.
Opposed? Okay, motion carries. And while we're on the pre-license exam course providers, there are two others that are up for renewal, and we need to approve those. Take a motion for their approval.
Is that 1 and 2, home prep education and American Contractors exam services?
Yes.
I make a motion we accept the renewal.
Okay, we have a motion and a second. Any discussion? All in favor, say aye.
Aye.
Opposed? Motion carries. Okay, Ernest, what?
This has reference to first place finishes, which holds a BC license, and they are, I guess, stating that they can do all the work on municipal construction, with the exception of masonry. I don't know whether that is.
What did you think about the website that they included with that letter?
I hadn't had a chance to look at the website. I was just given this when I was walking in the door.
Well, I'm sorry. I'm trying to get this on the agenda because it's an open complaint, and what happened was it's a BC who applied for an MU classification, but at the same time had an open complaint for doing MU work over $25,000. And when they responded to the consent order, I think we issued a consent order, they submitted a portion of our website that does seem to aver that a BC can contract for and perform work except for the specialties if it's over 25. So I think the BCs understand they can't do electrical, plumbing, or mechanical if it's over 25, but that they were under the impression that they could do the MU over 25. And Carol and I have talked about it some. I mean, it
is confusing. The rule actually says for MU that you have to have a BCB license.
And they've got the full BC. So
Right.
when you're looking at it, you think, well, we're good to go. And so I really felt like, I feel like the complaint should be closed because it's hard to discipline somebody when I really feel like there was some confusion about what they can do with their license, and it's our own website doing it. And, now that they've applied for the MU, and I need to check and see if they've got the MU. I just want to make sure the MU ad gets approved, and I'm trying to get the complaint closed, basically. Unless, you know, you want to make a example out of this person, but, you know, they know now they need the MU. Yeah, Carolyn has full access to that. It's just, it's a lot of information on there. And, you know, one person's going to go to the exact spot you know, and I'm sure she can go to that exact spot. But at this time, I would just like to get the ad class approved. If it hadn't been approved yet, it may have been.
Do you think our website is that confusing?
Well, I mean, I think the stuff about the BC is. I mean, she just said in our rule book, it says to do MU work, you need a BCB. Well, a BC includes a BCB.
And then there's a 60% law that says if you have a BC or a BCB, you can sub it out to a properly licensed contractor.
Do you think a reasonable person looking at our website would have made that mistake?
Well, Ernest has the file, and there's a couple of pages attached that show that part of the website, which I can show to you real quick. It's during a break or something.
The question is, a reasonable person will be confused by our website.
If I'm reasonable,
in your opinion.
then yes.
You do think so?
Yes.
And you think so too, Carolyn?
That is just very confusing. That whole rule and law is very confusing.
Get that revised pretty quickly?
Move the law from the website, but yes, I will revise.
Those are all of my comments, other than I don't know whether this is a standard practice or not, but some time ago, it's been, I guess, 20 or 25 years ago, I was on a job, and it was a utility construction project, and the contractor was doing everything, but we were doing the masonry. He was doing piping, everything. I'd see a laborer doing piping. So I don't know how long this has been going on, but we were union at the time, and I guess we were the only union contractors on the job. So I don't know whether it's a standard is or not.
Well, I think these guys are just going to start getting the classes. I don't even think they had to take a test for what they got. Now they have it on their license.
And this was a policy that was adopted, probably in 2002, 2000, something like that. It's when the board had said if you have a BC, you can do MU. So that adopted policy.
All of MU or just MU-B?
All of MU.
So do we need to formally approve something here?
I would want to formally approve the MU ad class for first place finish and close the complaint.
We need a motion.
Does that need a motion, or can he just sign off on it?
Well, I mean, it needs to be approved just like any other thing. You know, it's just not on the agenda.
So moved.
All right, all in favor, say aye.
Aye.
Opposed? Motion carries. Okay. I think we are done approving applicants. The legal report from Jenny.
Okay, the residential subcommittee reviewed the residential portion of the legal report and made the following changes. Item number 17 on page, it's either page 8 or 9, it was marked for a $1,000 civil penalty along with a formal hearing, and the residential subcommittee recommended a $5,000 consent order along with authorization for a formal hearing. Going now to item number 36, it was marked for discussion, and the subcommittee recommended a letter of warning. and item number 38 was marked for discussion. That was also one of our interviews, and the board member recommended a $1,000 consent order, which will have to be paid before the license will be issued. The commercial subcommittee reviewed the commercial portion, which was just one case, and I approved that, which was foreclosure. And then I have one more issue, but do you want to vote on the legal report first?
Yes.
Okay.
I move for approval.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
I think it was last board meeting, the board approved me to request the Attorney General to consider filing for an injunction in one of our unlicensed cases, and that went up and has been denied. I don't have a formal letter or anything yet. I just have the correspondence between me and the Assistant Attorney General over there. And basically, there is a criminal case going on right now on appeal on that. There is a civil case ongoing between the contractor and the city, and I can't tell you the entire basis for the denial. I know part of it was that those parties, at least in the civil case, were requesting they not get involved. Now, I don't know if the AG does whatever anybody requests. They obviously don't, but that may have been part of the consideration because there's so many things already ongoing with the case. So right now, that's all I know, is that it's on appeal on the criminal side. And what I mean by that is the circuit court in that county dismissed the charges of unlicensed contracting against the guy. They said he's not engaged in unlicensed contracting. I believe everybody on the board, if they knew all the facts, would disagree with that. I disagreed with it, and the Attorney General's office disagreed with it, and they have filed a brief in that case. So I do have some comfort in that we've got them fighting on that issue on the criminal side. I don't know what the final result will be. Also, fire prevention has gotten involved in the case. You probably know more than me about, there's 3 ongoing projects, and fire prevention has its hands on at least one of them. For whatever reason, they're not involved in all 3. And so fire prevention is forcing them to get their plans together to submit to them. There hasn't been a stop work order or anything, but there has been compliance on the fire prevention side. So there has been some movement, but there's no, like I said, no injunction. So that's really all I have on that. I just wanted to let you know, because I will have to, I've got some people calling me constantly wanting to know, was the injunction, are they going to file for the injunction? And I'd rather y'all know first than that person. So yeah, now probably already, but forgot. I'm sorry.
All right, Mr. Chairman, I would like to address Company 20340. It's an open complaint, and I did interview the owner of the company, his attorney, and the company that the work was performed for. And all 3 of them are here if anyone needs to ask any questions. But basically, they did submit a bid over their current license, and there's a whole host of reasons: company busy, owner not paying attention, new estimator, and then when they turned in the bid envelope, the power company had an engineering company, from understanding, looking at the bids, and shouldn't have gotten past them, but it did. And they admit that they did wrong, and so I'm recommending a $5,000 consent order. The job's within 2 weeks of completion, and I do feel confident that there are steps that have been put into place with the Lexington Electric system for this to not happen again in the future. And with the electrical company, I have their file to increase their limit to unlimited, and the paperwork is in order. So my recommendation is a $5,000 consent order, and we approve the unlimited increase for the electric company.
But only after the payment of the consent order.
Absolutely, after the payment of the consent order. Yes, thank you, Bill.
Any other discussion? Do we have a second?
A second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Any other legal report or discussion? Okay. Let's move on to Carolyn's report.
First one is legislation update, and this is in your iPads. The first bill that we're looking at is the roofing bill. House Bill 480. I do have a final public chapter, a signed copy if you all want to see this, but this basically says that roofing subcontractors will now be required to perform work, to be required to be licensed in order to perform work over $25,000. Judy and I have discussed it, and we don't believe there will be any rules needed. It appears to be that a subcontractor, roofing subcontractor, would just get a BC 21 license, or if he had a BCA or BCB, that would allow him to do roofing under either residential or commercial.
I agree.
Not the BCA little R.
Well, the BCA are, you could do roofing.
Yeah,
residential.
I mean, if there are going to be exceptions like that, that would definitely need to be in a rule. So when I say no rules are needed, I just mean just off the top of my head when I'm looking at the new law. So if you all between now and July kind of see some problems in the field coming up, maybe somebody's asking y'all some questions about it, and you think there needs to be some rules to clarify some things, we can do that. I think that the law is going to change again in the next couple of years. The way I saw it this year, they're going to try at least. I'll still do rules, but it's hard to know what they're going to do. I couldn't predict. I just think the lobby is working hard to get licenses for everybody.
There's no action on our part for that, correct?
I believe so, but does anyone in the audience have questions?
Please step to the microphone.
Mitzi Spann, Home Builders Association of Tennessee. I guess my only question will be is how it's going to be policed, because there's no roofing permit for just a roof. So I think even with the new license requirement, I think it's going to be tough to police it. So I just kind of wondered what y'all's thoughts
Supposed to be
were
a
on
permit.
that.
There's supposed to be a permit in Davidson County.
In Davidson.
And
but
Williamson.
Just where there's a home improvement, anything that's... But most places don't require a roofing permit.
Most places don't enforce it,
Okay, all right.
but it's there.
That would be my only question.
With the Home Builders Association of Tennessee. I have a meeting tomorrow with the Tennessee Roofers Association to talk about moving forward. Their concern is very much like ours was many years ago when only a few counties required contractor licensing. We see the same thing with home improvement. 9 counties require licensing and the others don't. My question to you would be, is this an opportune time to look at changing the law and having home improvement licensing required in every county in Tennessee, rather than a county opting in? You know, do we move forward now with requiring licensing? Because their goal is not new construction, it's existing roofs. It's going in and fixing storm damage, it's going in and replacing roofs, and there's no oversight. And I guess we can relate to that as contractors. There's no oversight, there's no inspections, there's no anything on roof repairs. and they can share certainly all of those horror stories with legislators as to what they're seeing with roofs out there, because they have to go back in and fix somebody else's work. Somebody whose pickup truck is long gone to another storm, to another state. So is this an opportunity, perhaps, for us to move forward with that kind of legislation? Could we partner and maybe do that? And if we did, would we have the support of the board? And certainly we would look for support from the department. Those are the kinds of conversations we plan to have tomorrow. And if you have any thoughts about that I can carry those thoughts forward, that would be good too.
I agree with you that there needs to be legislation, but crew of my roofers done a 24 square house the other day in 8 hours. Completely tore off, completely replaced, and they're gone. They're done. Outstanding job. I don't know if we get legislation that comes in and then all of a sudden we're going to have a tear-off inspection and they can't get there till the next day. That's really going to cause a hardship on contractors to not be able to get their work performed timely. That's an issue that I would harbor. Could we work with it?
How would that be addressed currently in the home improvement law? For the between the 3 and 25,000. How is that addressed today in Davidson County, for instance?
It's not,
Williamson
other than
County?
the fact that you've got the license and you're qualified, and you pull the permit.
I like the idea of having a statewide standard for licensing. I don't know that just requiring a license would necessarily require changes in the inspection or situation at all. Seems to me that our reviewing and granting licenses is a consumer protection issue, and it seems to me that every county and every home in the state ought to have that kind of protection. So my personal opinion would be, I think it would be a great opportunity if y'all want to pursue that. I would certainly do that. I can't speak for the rest of the board, but I think it would be a great thing.
It would make it a lot less confusing. I mean, right now when somebody calls to say, do I need a license for work under 25,000, you have to say, okay, what county do you want to work in, and is it this kind of work or that kind of work?
I think you'd have the board's approval and backing. We just never could get it passed with the rural rural legislatures. If you can get it passed, we're for you.
Well, I'm just wondering if now isn't a good time with there's a whole lot of moving parts, and maybe they're moving now in the right direction. And you're right. I think inspections and permits and everything would probably be a separate issue, and maybe we don't take all that on at once. Maybe we just take baby steps to get to where they ultimately need. I think I might move away from the window. So, if you have any more thoughts, give them to me, and I'll carry that forward to the meeting tomorrow.
Any more discussion?
Another bill that passed is the House Bill 328, and this concerns exceeding the monetary limit, making it, actually it clarifies that it's a violation. There was, I think, a lawsuit where the judge did not feel like, what was it, they overruled and said that he was considered licensed. Do you remember?
We're talking about Anchor Point.
Mm-hmm.
Well, there was a Court of Appeals case that decided that they would let a contractor, I think, obtain profit even though he was over his limit. Whereas used to, if somebody was over their limit, the court considered them unlicensed and you could only get documented expenses. That has not gone up to the Supreme Court, but I mean it does hold weight, and it may make a difference on the upcoming cases.
And Bob Pitts from ABC couldn't be here today, but he did say to let the board know that this law was, the reason why they lobbied for this law was to make it so there's more teeth in the law to go after people that exceed their monetary limit. And he did say if there was anything that would hinder or prevent you from going after contractors for this law violation, that to let him know, and he'd get with the associations, for whatever law changes are needed to make it so we can go after contractors for violating the monetary limit. And this monetary limit law did keep the 10%, so that's still there.
That law case, that legal case didn't have any effect on our ability to impose this, a penalty, right?
No, because under our statute, we can penalize up to $5,000 per violation for unlicensed and violation of terms and conditions. So either way you look at it.
The other bill that passed was the one that deleted 626-127 that makes the contractor's license law for over $25,000 now statewide. It deleted Sequatchie County. So Sequatchie County now has to have a contractor's license. There are also the House Bill 551 for employee misclassification passed, and that's a committee that Bill and I are on, so that was the work we did helped get that passed, and so there are penalties in place. And the 6-month hold that goes into effect as well, that you no longer, you have the discretion, instead of you shall hold it for 6 months, you may hold the license for 6 months. And I believe that's it for the legislation update. Do you have any questions?
Thank you, Carolyn. Are you going to lead us in individual use license exemption?
Yes, I can go ahead and do that. We received a inquiry from a company called Nucor, and it says that all their upcoming projects were going to be for individual use and not open to the public or for sale or rent, and that they were the owners managing their own property. Now, the individual use law does exempt them, but as far as I know of, it would be only for like a warehouse or storage building. They wouldn't be able to build a manufacturing plant, right?
I mean, yeah, right. I mean, the new rule we just passed says it can't be for use by the general public. So,
Yes, I don't agree with everything he said. He says the general public won't be allowed there.
right. I mean, I didn't really like the name of this on the agenda because I told Carolyn, I'm like, we're not exempting him. He just doesn't need the license, So in this case, I mean, unless you all disagree, I think that this is probably okay. I mean, he's an individual owner building something that's for his individual use, and
$15 million
For his business.
I'm not sure about that.
well, you can look at the new rule. I mean, let me. Do you have rules in front of us?
A company can build a great big $115 million thing, so, well, it's just for us, so we don't need to have a license.
Let me read the part of the statute that we're talking about. 62.6.103, and it says, any person, firm, or church that owns property and constructs on the property single residences, farm buildings, or other buildings for individual use and not for resale, lease, rent, or other similar purpose is exempt from the requirements of this part. Okay, and then that's in the statute law. Then we just did a rule that backed that up just to clarify these kind of cases. So that's why I'm pretty.
Question. That being said, Nucor goes out of business. Does that you have to tear that building down, or can anybody else use it for something else at that point?
That's a good question. I don't know.
I just don't think that's the intent of that law.
Well,
I just don't believe that. I think that, and the idea that they can build a $115 million facility, and no one ever is going to go into that except the owner of that business, is that defies credibility to me. I don't think. Opens the door for all kinds of businesses to build all kinds of facilities that are going to be used for their business and not have to have the proper licensing for it.
Well, I guess, what do you think the intent of that language in the statute means?
Red, I mean, you're kind of classified. You gave three things: residences. What was it? Residences, barns, and
or other buildings for individual
other buildings. So you're putting
use.
this under building for individual use.
Yeah.
This isn't for individual use.
So you think it doesn't apply to commercial commercial owners?
Absolutely not.
Well, we may need to change the rule.
Well, we may need to clarify the rule, but I just don't think that was the intent of this rule, because I don't think it's for individual use.
I couldn't agree more. If you're going to have employees working in that building, it's a $115 million building. They're bound to have employees living and working in that building
Well, you
every
don't think
day.
they're going to have codes out there, Carolyn? I mean, you're going to file a owner, yeah. Well, I mean, we don't go around making people pull building permits. People pull building permits because the local codes is going to come around if you don't. It's not because of the board. I mean, that's my experience. I mean, they're going to get shut down by local codes if they don't pull the permits. I mean, it's up to you all. I'm just telling you what the statute says and that we just did a rule on it.
You read the statute, and I don't think that statute applies in this case. In my opinion, that this facility for this commercial operation, just other buildings for individual use, I think that absolutely doesn't apply in this case. And my opinion would be, and I'll make it into a motion, that this contractor is subject to the contractor's license law for this facility. I move that this board issue an opinion that this contract is subject to the contractor's license law for this facility.
Second.
Got a motion and a second. Any other discussion? All in favor, say aye.
Aye.
Opposed?
Should we get an agent?
There already is one, but I don't have it in front of me, but I'll be sure to bring it back in July.
Wouldn't this be similar to this case that you brought up before that we were trying to get an injunction for? It's an owner that's building what he says for his
no,
individual.
because the buildings in that case was a bed and breakfast and 2 apartment complexes. To me, there is a difference.
Public.
Yeah. I mean, in the AG opinion, I don't have it in front of me, but it does differentiate between the public and employees of the business. And I can try to go get it if you want me to during the meeting. But it's still up to the board about, deciding what you all think the intent of the law is, so.
It'd been my barn, a barn they were building, I'd be okay with it. If it was an
What if it was
outbuilding,
a $200,000 barn? I guess I'm just getting at, I don't think the financial needs to be the threshold necessarily, always.
I agree with you wholeheartedly. But I still say, I think the intent was for some non-manufacturing, non-public use building. I don't think we're speaking about something of that nature in a $115 million building.
If you have employees, it's not.
You got delivery,
You
you
have
got
people in there. Like a barn that you have in your
And if you let
backyard.
somebody in to fix the TV cable or the electrical line.
Well, and Bill's right, we may need to clarify the rule because, the rule we just passed is just to clarify the statute. And the last sentence pertains to this. It says, the exemption does not apply to persons constructing buildings for a business-type purpose that cater to and depend upon usage by members of the general public. Now, I pulled that from the Attorney General's opinion. So, they were differentiating between the general public and employees in the Attorney General's opinion, but the opinion's probably 15 years old or more. I mean, we can request another one, or you can just go with what you said today. I mean,
I think we've already said. I think we're pretty.
I was
clear
just
where we are
talking.
on this. Yeah, yeah. So I think we know where we are on this.
And the next item is we have a request from the state of Georgia for reciprocation with the electrical exam. And I'll turn it over to Cindy. She was reviewing their information. She can make a recommendation.
After reviewing Georgia's, their request for financial information, their application, their testing, I do make a motion that we reciprocate the CE with the state of Georgia.
Okay. Is there a second?
Second.
Any other discussion?
Yes. Do we reciprocate with them on any other thing?
Right now, commercial, and they are talking about plumbing next time.
It's just my opinion. I think if we reciprocate with the state on anything, we need to reciprocate in all licenses. Because I understand that some states have separate boards, but it's confusing,
Georgia, they do have separate boards.
especially when you start talking about the proximity of state lines like North Carolina, Georgia, Alabama, and then, okay, well, yeah, we reciprocate with them. Well, come to find out, we only reciprocate the electrical license. And it causes a great deal of confusion all the way around. And I think that's something that the board really should consider highly. I mean, I'm not against this, and we'll probably vote for it, but I just would like to see us do a blanket type move if we do it.
Any other discussion?
I do have a meeting. Several of the bordering states are getting together on May 30th to relook at reciprocation. And since I can't travel, I'm going to participate by phone with Mississippi, Arkansas, and Louisiana, and Georgia as well. But what they're proposing is probably something we would not be able to do anyway. And it doesn't look like any of the other states. They are wanting to make it so whatever financial statement requirements are in their state, it would be the same for this state, and that can't happen because it's a law. But I did want to let you know that we are going to be meeting in a few days to relook at the reciprocation. But as far as doing a blanket for each board, for everything in each state, that would never happen either. Like Alabama, for instance, Alabama, we have a reciprocal agreement with every board except the plumbing board, and so they will not be in North Carolina is similar. We have a reciprocation agreement with them for commercial, but their electrical and their mechanical, they won't consider us. So residential. I'm sorry, residential they do. Sorry. But I'll give you an update after the next meeting on the May 30th meeting.
Okay. Well, we'll call the question on accepting the reciprocation for the electrical with the state of Georgia. All in favor, say aye.
Aye.
Any opposed? Motion carries.
Next item is home improvement bonds, the release policy. What our rule says is a bond may not be released until whichever occurs first, either 1 year after the license is inactive or after any pending claims against the licensee filed during the period described have been heard or satisfied. So that's all it addresses in the bonds. our issue is we have property and cash bonds, and this is something that we probably need to ask for a law change, because the property bonds and the cash bonds are very difficult to track and keep up with, and not just for us but the contractors. But we need something that will at least let us notify a home improvement contractor after they've been expired for even a year. We have some that have been expired for several years, and they have cash bonds and property bonds still with us. And when I say cash bonds, this was literally $10,000 cashier check that we deposited, and it sits in a non-interest-bearing account. And we Googled some of these and found that these people have actually died. Their estate probably doesn't know that it exists, as well as their property bonds. It could be that their property can't be released because we have it, and they don't know that we have it. So we're just wanting to come up with some way to at least notify them, that just to make you aware that your license is inactive and you have a bond on file, and take steps to collect it. Do you want to add anything?
Yeah, I
Need a
mean,
law for that, do you?
no, they had just come to me and asked me about releasing the bonds. And I just think the board needed to be the one to say, hey, we have no problem with staff notifying expired licensees, that they need to do it. A lot of the guys do it themselves. Most, do. So
Sometimes they'll contact us, but Talise is following up and found that we have several bonds that.
Faith effort to find every one of them?
Yeah, with the internet, you can find them. So you can find the estate anyway. Okay, good.
Vote for that, do you, Carolyn?
I guess they would for a policy.
yeah, I would think a vote's good for policy.
Motion.
I would make a motion that the staff make a good faith effort to try to return any and all cash bonds, property bonds to expired contractors' license fees.
Home improvements, right?
For home improvement, correct.
Okay. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Okay. Audited financial statements.
We had a request from a CPA that wanted to make a suggestion that we could save contractors a lot less money if we remove the requirement of for the audited financial statement to not have to include profit and loss statements or statements of income and cash flows. And I did discuss this with the accountancy board and a bonding company, and we also got an opinion from another CPA, and they said absolutely not, that you need to keep that. But I wanted, since you all are contractors, you know best, I just wanted to present it to you to see if you want to consider removing that from the instructions or leaving it as is.
As is.
I agree. I think we need that information to determine the financial situation of the contractor's applications. Do we?
We need to vote for that as well.
No, I don't think so. It's already in place. So.
Yeah.
Last item, rebidding opinion request. This is also in your books. We had a contractor who in error listed a licensed plumber. I think it was his mechanical part, the HVAC part, but he accidentally listed him as the plumber part. So they contacted me, and based on the law, I told them they had to, it was my opinion that they would need to reject it based on the law. I pretty much just told them what the law was, and that's what the city council voted to do, was throw out the bids. Now he's come back and wanting to know if he can rebid. because they're going to reject all bids and put it back out. And so he just wanted it to go before the board to see whether or not he could participate on rebidding, since he listed an unlicensed plumber in error, but that he is licensed.
Our policy has been that if you make a mistake on your bid form, that you are not eligible to rebid.
You wrote it in the past.
Listing of subs. I know
Well,
when you went over your limit.
It would be considered, and you've got one rule in here, Carolyn, but there's another rule that kind of goes to it, and it says if you are unlicensed and participate in the bidding, or you violate the terms and conditions during the bidding, then you can't rebid. So I guess my question is it a violation of the terms and conditions of his license to make the mistake of listing an unlicensed plumber? And then it also, in the statute, says any person or firm who is engaged in contracting without a license is not permitted to participate in rebidding. So, I mean, it seems like the intent is to catch people who are totally unlicensed.
Done that before, you know.
Yeah. I mean, it's a hard question y'all have had before, so it seems like this was an inadvertent mistake, but I'm not positive.
What we don't want is bidders filling out bid forms inaccurately and finding out what the other bids are and then being able to rebid knowing what everybody else is. Hard to say whether it's a honest mistake or a mistake that he now has information that could help him in the next bid.
What have we done in the past? We've not let him rebid?
I think the contractor that makes the mistake, we've said, is not eligible to rebid.
We open a can of worms, we start making exceptions. Are we talking about making an exception just for this one or some kind of policy change?
We just had a contractor ask us
For an opinion.
for an opinion.
We open a can of worms if we make an exception here.
I think the burden needs to be on the contractor that's filling out his form to do it properly, and if he doesn't, there is a consequence for it.
I think that it sounds like the awarding authority is going to go with the board's opinion. I'm not for sure on that, but they seem to be waiting.
Right, that's
that.
what the architect.
I know they rebid it. Well, they threw out all the original bids,
Right,
right?
but the architect said they did want to know what the board's opinion was, but the contractor is the one that actually submitted the request.
I think he
Did I read, was he the low bidder?
Yes.
I think he should be ineligible to rebid.
Have general consensus on that? I believe so. Our opinion.
Tomorrow, I think we're like number 6 on the sunset hearing review. I do have, and it's in Legislative Plaza, room 16. I still don't have anything as far as parking places for you all tomorrow, so unless I get something later today and call you or text you that information on parking spot, try to do what you did today, and then we can meet out here about 8 o'clock in the morning and have them drive us to the Legislative Plaza. Okay, do you want me to revise the time? for Tim
Well, I
to
mean,
pick
me
us
and
up?
Carolyn will have to,
Almost
I mean,
a
I'll
question.
have to be
That
up
was almost
there.
a question,
Yeah.
not a statement. but
Well,
we're-
we'll have to be up there because sometimes they will take it out of order. So we have to be there. I mean, I can't.
Carolyn can.
Yeah, I'll be happy to say they're on their way.
What room's it in
Appreciate
again?
you.
So we're going to meet in the
16.
lobby of this building at 8 o'clock tomorrow morning.
Right.
Okay. The next board meeting scheduled for July 30th and 31st in Nashville. Okay. I guess that's it, isn't it? All right. We need a motion to adjourn.
So moved.
Second.
All right. We're adjourned.